I may approach, my name is Christopher King. I'm a former escrow attorney. I've been a professional journalist for years, and this is what I do. And it's consistent and consonant with the First Amendment to the United States Constitution, various statutes, state constitutions, and all of that. As I noted in my notice of media coverage today, some of Mr. Shearer's co-counsel may not appreciate what I do, and they unlawfully threaten me with arrest, but I stand firmly by what I do. I've never been admonished by a court. I've never been refused access by a court in the last 6 or 7 years, and that's the law. With all due respect, Your Honor.
Okay.
Counsel, I had a quick question. Do you know of any case law, though, that would support, let's assume arguendo, that the documents are fraudulent. Do you know of any outstanding case law that says that a trustee may proceed with a foreclosure sale using forged documents?
Well, if you're asking me about this case, I can't comment on this case.
Right, but no, of course not. But just in general, have you ever seen any case law that stands for the proposition that a trustee may knowingly use false documents, toward a deed of trust to foreclose and sell a house?
I don't know every case out there.
Right.
I mean, you're assuming a lot of hypotheticals in that question, so I don't really know how to answer your question.
Well, I know, counsel. The only hypothetical I'm assuming is that the documents are forged.
Okay.
That's the main premise. And then,
question?
yeah. So, do you know of any law that says that a trustee can knowingly use forged documents in a foreclosure process and then sell a house using those forged documents that comprise the deed of trust?
What documents?
The deed of trust, as she claims.
Okay. I'm still not quite sure how to answer. Like I said, I don't know every case that's out there.
Sure.
I'm not that smart, but I don't really know how to answer that question because it really depends on the specific facts of the case. I mean, every case is different.
Of course they are.
So, in terms of something in a deed of trust, you'd have to ask the parties involved in enforcing the deed of trust.
Well, but if Northwest Trustee is relying on that deed of trust as part of the means and fabric of the foreclosure, and the deed of trust itself is fraudulent, then doesn't that constitute a problem?
Fraudulent's a legal conclusion.
I mean, again, if the facts are as she alleges.
You're talking about her again. I can't talk about this case.
Or if the facts are as any litigant would allege, okay, any litigant in a like situation to Ms. Shcolnik, okay, if any litigant similarly situated to her said, I didn't sign those and was out of the country, do you know of any case law that would support the right to foreclose?
Sounds a lot like the facts of this case that I can't talk about.
Fair enough, man.
Well, let me put it this way. I think if a loan document is signed or not signed, it's somewhat easy to determine ultimately whether that's true.
Right. And that's her allegation in the other cases, in the other half of the cases that.
I'm not talking about her.
Oh, okay, but right, that's fair enough. Fair enough.
But I'm just saying, it's one of these things I rarely see ever raised as an issue because it's one of these things. There's really no gray area, right?
And that's what I'm saying. That's why this case is so compelling to me. I want to find out, were these people there or not?
This case.
But I know. But again, we're weaving in and out. But of course, that's why, particularly this case is compelling to me because I've never heard a situation like this either. Yeah, it's different.
Every case is different.
Yeah.
Every case is different. So I don't know. In your situation, you're describing hypothetical facts about some other case where something might be fraudulent. You'd have to give me all the circumstances of some other case for me to answer that question. And every case is different.
Of course.
So,
yeah.
That's the only way I can answer your question.
Yeah. I know. We'll see where it turns out. I guess on the other side, in this, weaving back into this case, in the other side, I guess she's taken up an appeal with her son, and they want to compel those 3 people to come in, and I think she has a right to do that. Like those, if they're on my note, if they're on my mortgage, rather.
Or tell you anything about
it. Yeah, I know.
Case.
Oh yeah, we're just rapping, man.
I can't discuss pending litigation.
I hear you. Yeah, we'll just see where it unfolds, but it's got to be interesting. But wordlessly briefly, I guess I want to tell you congratulations. That was actually kind of a victory from what I perceived, that the court did not dismiss your claim under the little RICO. And I guess you may need to write a more definite statement.
Well, he just said...
They're going to ask you to do that.
Well, yeah, I can't remember what he called it. But he said
the next step he's going to file something about.
A more definite statement. That's
He
fine.
didn't use that word, but that's probably what it is.
Sure, and I was thinking as the court was going through its, motions in there that, you may want to just ask for leave to file an amended complaint, which is basically the same difference. But
I put that in there because as I researched things, that's a good thing to put in to be able to amend it.
Sure, of course, and you're not trying to, Hi. But yes, well, that's good news, and well,
it seemed like it was. The whole thing was going to be dismissed the way the judge was talking at first.
I thought so too, but I was surprised when he did not dismiss little RICO. And I'll tell you, you heard my colloquy with Attorney Scheer afterward, in which I asked him, I says, I couldn't pin him down because he's a sharp cookie. But the bottom line is, I don't know of any case law that says that a trustee could use poisoned documents to foreclose. That's the whole point.
See, I don't understand. In fact, before they filed the sale, people, that knew my situation said, well, they might never do anything with those documents because you've already told them they're fraudulent. And if they tried, they would have to do something judicial because you've already told them this. So that's why it was somewhat shocking that they not only used the old one, that they updated it because it was an incomplete fraudulent deed of trust. And that's the only way I can. Of course, fraudulent, I guess I have to be careful about words, I guess.
Term of art.
Fraudulent is a legal thing.
Legal conclusion.
Valid, so I have to be careful with that, But,
yes.
And I don't know if that is a problem then when I'm talking to the judge, if I'm using those kind of terms, if that hurts me, or if he understands, I might not know. But then as you go in as a pro se, you're supposed to know everything.
Well, what I think the court heard you say today was, look, I was nowhere around when those documents were allegedly signed, and as far as the predicate acts go, I think the issue is each and every time they try to use those documents, a predicate act could be a court filing. Every time you use that forged document, that's a predicate act.
And I don't know if but when they filed this motion, it specifically says in there that the plaintiff admitted executing the documents.
No, you didn't.
Exactly. I mean, isn't that what do you call that?
Well, that'd be maybe a motion for Rule 11 sanctions, but I can't advise you on that because guess what? I'm not your attorney.
But you see what I mean? I mean, the whole basis everywhere, that's my whole basis of my claim is it's based on I didn't execute those documents. So when I saw that, I thought, who wrote this? Or were they even reading it really was surprising, And then they even said, she doesn't challenge any of these documents. I challenge all the documents. So it does get confusing, and to me, it's hard to understand where the court draws the line and how you can misrepresent things.
How much you can lie? Right.
Yeah, misrepresent.
Well, thank you, Ms. Shcolnik. I appreciate you taking time for the interview.
Okay.